Good morning, everybody. Mr. Gill, it is my understanding that the defense has some matters that it wishes to place into the record regarding the pending motion to change venue. Is that correct?
We do, Your Honor.
Go ahead.
We have what have been marked as defendants exhibits 228, 229, and 230. 228 and 229 are recent editions of the front pages of editions of the Star Telegram, and 230 is a DVD containing a number of recent news stories from local media outlets, a lot of which we were provided in discovery by the state.
State have any objections to, for purposes of this hearing, to defendants exhibits 228, 229, and 230?
No objection for purposes of this hearing to defendants exhibit 228, 229, and 230.
All right, they're admitted. Do you have any additional evidence that you would wish to offer in regard to the motion for change of venue?
We do not, Your Honor. We rest on the motion.
Does the defense have any evidence that it wishes to present in regard to the motion for change of venue? Any additional evidence?
No additional evidence, Your Honor. The state would, the main evidence the state has would be the panel's response during voir dire last week.
Does either side desire any argument, final argument on the motion for change of venue? Defense?
We do briefly, Judge. We waive our right to open and reserve our right to close.
Mr. Smith? And I have the state's bench brief that was furnished to me previously. Oh, good morning.
Good morning, Your Honor. Just briefly, as you mentioned, the state filed a bench brief, just to highlight some of the points in that. The defense has a heavy burden in a change of venue motion to either establish that the prejudice in the community was pervasive, prejudicial, inflammatory, or under the second prong, that there was a coercive government force that would have influenced the ability to have a fair trial in this county. Briefly touching on the pervasiveness of the prejudice, or of the media, most coverage of this case was in the immediate aftermath of the offense. Since the offense, the coverage has been mere case updates and included the original information that was provided in that original coverage. Additionally, there's been no indication of the viewership of the vast majority of the media coverage that the defense has offered into evidence. There's been the Star Telegram circulation numbers, but we have seen the evidence has been from other news sources and things like that, with no indication of viewership. And without that, there's no way to know how many people in the community have actually viewed that. And most importantly, in regard to the pervasiveness, the jury panel last week and the Benai panel truly showed that the pervasiveness of the media attention in the county is not as high as the defense would make it seem. When we compare the numbers of the Benai panel that had heard of this case to those in other cases, specifically the Gonzalez case, which was cited in the state's brief, 57% of the Benai panel had heard of this case before, which is really in line. In Gonzalez, the Court of Criminal Appeals noted cases with 67%, 63%, 61%, and 81% of where the Benai panel had heard of the case, which is very in line with what we have in our case, in fact, even more so. And out of that 57, about 25%, and that number is even a little high, of the Benai was dismissed based on their exposure to pretrial media. And it's within this court's discretion to believe the jurors' assurances out of those who were questioned regarding their pretrial media exposure, that they did not have preconceived beliefs or beliefs that they could not set aside in rendering a verdict in this case. Based on just the number of the Benai in this case and the media, the evidence just does not demonstrate that pretrial media publicity has been pervasive. In regard to the prejudicial and inflammatory prongs of that first 3103 claim, when media is accurate and objective, that goes against a finding of prejudicial and inflammatory, and that's largely what we have in this case. The media Coverage of this case has been just that, accurate and objective, reporting on the facts of what happened and the case updates, what the trial proceedings that have occurred in this case. In addition, although the body camera has been released to the media, that is evidence that the jury is going to see. In case law, as mentioned in our bench brief, supports the fact that when it is evidence that is going to be presented and it's done in an objective, accurate manner, then that weighs against finding prejudice and inflammatory. The media attention in this case has not been pervasive, has not been prejudicial, and has not been inflammatory. The law does not require that jurors be completely blind to the fact that this offense occurred, merely that they be fair, and that's what our benign panel showed that they are going to be able to do. So we would ask that the court deny the change of venue motion on that first prejudice of the media prong. In regard to the dangerous combination, which was raised in the supplemental bench brief, the Ricer case, that we cited in our bench brief, is strikingly similar to the facts of this case and demonstrates that in order to justify a change of venue based on a dangerous combination, it's not just that community leaders spoke out about the case or maybe even spoke to each other about the case. The defense has a heavy burden, again, to show a coercive force that could influence the proceedings and the right to a fair trial. When comments of community leaders are made in the immediate aftermath of the offense, it is not likely that they are acting to impede the fair trial, and that's what happened in this case. Again, like the Ricer case, community leaders spoke out about the offense, but there's no evidence of how those comments by the community leaders influenced the community as a whole, and as was demonstrated during voir dire and being able to select a jury in this case, there's no evidence that it would have impeded the defendant's right to a fair trial. So we would ask that the court deny the change of venue on a dangerous combination grounds as well.
Thank you, ma'am. Mr. Gill, response.
Your Honor, thank you. First of all, I have two major disagreements with what the state just told me. Number one, the majority of the publicity of this case did not occur at or around the time of the event. The coverage has been steady and pervasive throughout the 3 years that this case has been pending. Every single event that has occurred at this courthouse has been widely covered and widely publicized, including routine court settings, including the change of venue motion and testimony itself, up to and including last week with the death of Mr. Lane and the beginning of jury selection. All of those matters have been widely publicized and widely distributed around Tarrant County. We presented you the Star Telegram circulation figures. We also presented circulation and viewership figures from KTVE, Channel 11. It shows the number of households that are reached by their news broadcasts. We were stonewalled by the other media outlets in Tarrant County to get that information, but you can also see from the pervasive nature of what the actual Benaire members in this case saw, that the coverage has been pervasive. And in fact, there's been a previous finding in this case that the coverage was both pervasive and prejudicial. That finding was made by Judge Hagerman last summer, even before the recent news coverage, the recent spate of news coverage. Also, the coverage has not been accurate, and the coverage has not been objective. And that goes to the inflammatory nature of the publicity in this case. It's been inflammatory and it's been prejudicial because most of the news coverage has been inaccurate. Most of the news coverage has said that Aaron Dean went out to his home on a welfare check, which is absolutely and totally wrong. The news coverage has had the mayor and other leaders of Fort Worth standing up in front of them, which have been, these news conferences have been shown time and time again, saying that the weapon possessed by the complainant in this case was irrelevant, and they don't know why that is any part of this case, which is going to be a major part of the case. There are a lot of other factual inaccuracies that we see as we go through the coverage in this case, and you will see, and you have seen when you reviewed all the news coverage that's been introduced by the defense in this case. The news coverage has also been extremely emotional and presented from the standpoint of the complainant. It's all been about the family waiting for their day in court. And I'm not saying any of this is wrong, But that's how the coverage has been. The coverage has always been told from that standpoint, about the community standpoint, about justice for Atatiana. It's been drilled into the heads of the veneer that way. And it's been presented in a racial aspect of it. It's been presented and emphasized that it was a white officer that shot an African American female. And all of this is presented time and time and time again until it's become a theme and a mantra of all this coverage that has continued until this very day. Under the dangerous combination prong of the change of venue statute, 3103 of the Code of Criminal Procedure, we have shown you that the mayor and the chief of police and the city councilman, all widely publicized, have taken, at least the mayor and the chief of police, have taken what they knew to be the truth and twisted it and made a presentation to the public that is different from what they knew the truth to be. And that has all worked to the detriment of Aaron Dean. And that is dangerous, and it's a combination of individuals that did that. A combination of influential persons. There is no one more influential in the city of Fort Worth than the mayor of Fort Worth and the chief of police of Fort Worth and the councilman of the city of Fort Worth. And we also presented you testimony that the district attorney was involved in making sure this case got moved along, and that the case was presented in the light shown by the mayor and the chief of police. So the coverage has been inflammatory in that regard. It's been inflammatory on the racial and the factual inaccuracies that have been presented to the public. And we saw how much that pervaded the jury panel when 109 out of 190 people raised their hand and said they'd heard about the case. We also heard more on Thursday from people that had not raised their hand before when they were concerned about security in the case. That means they had heard something about the case. They weren't raising their hands. This isn't something that normal juries raise their hands and ask about. I have never seen a jury raise their hand and ask about security for a case and how they were going to be kept secure by the court. That was a major thing that was on the minds of those jurors, and they didn't get that by walking in this courthouse without having heard something. You heard the testimony of Dr. Galusha, who testified that this is the kind of thing, publicity that the jurors have heard is the kind of thing that remains in their subconscious. So all of those people that did not raise their hand on Monday and say they heard about the case, as Dr. Galusha testified to you, they may be telling the truth. They may honestly believe they haven't heard anything about the case. But psychologically, if they're members of this jury and they're deliberating on the case, according to the studies that Dr. Galusha presented, those facts begin to creep out of their subconscious and enter into their deliberations to the point that the facts that they heard in pretrial publicity take precedent over the facts they hear at trial. It's the first in, first out rule. What they have heard, the primacy of what they heard first takes precedence over what they hear later on, and then they match the testimony that they hear in the courtroom to what they heard in pretrial publicity to confirm what they heard in the pretrial publicity, and then use that during their deliberation. And as I mentioned earlier, what they heard in pretrial publicity is inaccurate and not correct. So just because we have a fair juror or a jury seated in this case does not mean we have a fair jury. This case has been permeated with publicity, inaccurate publicity, inflammatory publicity, and even in light of the fact that there is going to be a jury that's ready to come out here and take a seat in the jury box and begin hearing testimony in this case, there's no guarantee under the Sixth Amendment that this is a fair and impartial jury. And we would ask that the court move venue to a place that has been subject to the pervasive publicity, pervasive, inaccurate, inflammatory, prejudicial publicity that this jury has been subject to.
Your motion for change of venue is denied. you may have a running objection throughout the trial to the jury. It is my understanding the parties have furnished the state's disclosure of documents that both lawyers have signed. Is the state's satisfied?
We are.
Defense is satisfied?
Yes, Your Honor. I believe I did 40 copies of files.
Oh, it has been filed?
Yes, sir.
Okay. Are there any other matters that we need to take up? The jury is present. Is there any other matters we need to take up before we bring them in?
Yes, Your Honor. The state would just like to put on the record that the court doors were open at approximately 8:30, I believe, between 8:30 and 9 o'clock this morning, and that the doors were open for anyone that stood in line to come in. There was the public, the gallery is full, so obviously it is an open court. And for the record, Your Honor, how many other courtrooms is the audio and video being piped into for closed circuit purposes?
There is a courtroom next door that is, receiving a live feed, and it is open to the public. In addition to that, there is a second courtroom across the hall that is available for the media folks. It is also open to the public, but it looks like Mission Control in Houston when you walk in there.
And so that's 2 extra courtrooms for the public to enter that would also be considered open courtrooms for purposes of the law and the Code of Criminal Procedure. Your Honor, also there's an agreement between the parties for the rule under 3603 in the Code of Criminal Procedure. Family members as defined in the code, sisters, brothers, are allowed to come in and sit and watch the trial even though they may testify at a later phase. We've represented to the defense that both one of the sisters and a brother of the victim may be testifying at certain phases of this trial. However, that testimony would not be materially affected by the evidence they may hear in the case in chief, and they'd be testifying not about the offense itself as it happened. And there is an agreement with the defense for also the defendant's, I believe, mother and father and sister to be in the courtroom to be excluded from the rule as well.
Is that correct?
We don't need the Code of Criminal Procedure. Dale and I are following the
All right. Thank you, counsel, for that.
And
Mr. Smith.
yes, Your Honor, the last thing is the state would request a motion in limine on the toxicology results of Atatiana Jefferson. At this point, anything that was found in the toxicology result would not be relevant, and we would ask that the defense approach and we have a hearing outside the presence of the jury before any of that testimony is in front of the jury, so therefore we can determine its relevancy and admissibility.
For limiting purposes only, is there any objection?
No, Your Honor.
Okay. Y'all just approach if we feel like we need to talk about that.
We will.
That's all the housekeeping matters the state of Texas has.
He's from the defense.
Yes, Your Honor. We also have a motion in limine, which would extend to everything on the state's 404B notice.
Any objection for limiting purposes only in regard to 404B?
For the punishment evidence, no, Your Honor. Our case in chief is only about the offense that happened on October 12, 2019.
Defense motion is granted. Y'all approach the bench if you feel like you need to talk about it.
Yes, Your Honor.
And to be clear, we're asking that this motion pertain to both phases of the trial.
Understood. Yeah, so if there's anything in regard to 404B, approach the bench.
Yes, Your Honor.
Okay.
Anything on their notice, Judge.
On their notice, yeah.
And also, we would ask for a motion in limine on any victim character or victim impact evidence at the guilt innocence phase of the trial, and also any victim character evidence at the punishment phase.
Any objection to that for limiting purposes only?
Not for limiting purposes only, Your Honor.
All right, that's granted.
Your Honor, nothing else.
Ms. Ford, will you be staying with us or are you leaving?
I'm going to leave council table.
The only reason I ask is we were going to have to figure out how to get folks in.
Yes.
If you would return your chair over to the jury box. And thank you, I appreciate your remarks.